Okay, now I'm gonna share my screen. Okay, hopefully you are looking at a slide that says 3-day notice to pay rent. Are you? Anyone? Are you seeing my screen?
Yes,
Great.
yes,
Yes,
I,
we see.
So this is the 3-day notice to pay rent. When I picked this topic, we were in the one day where there was no moratorium. So I thought this would be more relevant, but days ago, the CDC reinstated the eviction moratorium. If everyone could please mute themselves, I'd appreciate that. So if the tenant has not paid the rent, the landlord is required to give the tenant this notice. This is required by Florida statutes, chapter 83. And as you see, 83.56 subpart 3. And the 3-day notice must be this form to demand the rent. This is the form that actually acts to terminate the tenancy. So before you can file an eviction in Florida, you must terminate the tenancy. So if the issue is non-payment of rent, then the 3-day notice is the form that you issue. If the tenant is doing something else, then you would issue either a notice of termination or a notice to cure violation. But with this, it's the 3-day notice. And I'm going to switch over to the instructions. So this is, the 3-day notice seems to be simple, but there are many mistakes that you can make that will render it invalid. If the notice isn't done correctly, you don't terminate the tenancy. And therefore, if you file an eviction based on a flawed notice, you will lose the eviction and then pay the tenant's attorney's fees for your mistake. So the first thing is, who do you name on the notice? So the answer to that is anyone that's on the lease or anyone that is legally obligated to pay the rent. So if the tenant has children, you don't name them because they're not the ones obligated to pay the rent. So you're going to list the people that are supposed to pay the rent. Occasionally, a landlord will have a property where they don't know who the tenants are. So in that case, you're just going to list the tenant as unknown occupant. So if you're buying a bank-owned property that's already inhabited and it appears that this person is a tenant, then you'll have to try to figure out what the rent is and name them on the 3-day notice. So the amount claimed. So a 3-day notice is officially only a demand for rent. That means you cannot ask for any money that's not rent. So that would be late fees, utility bills, unpaid security deposits. Those aren't rent. So some landlords try to get clever and they will name all these other types of fees as rent. So technically, if you call something rent, then it's rent. But the thing is that judges and defense attorneys and legal aid will think that you might have made a mistake by adding those extra fees. So if the rent is $500 and your 3-day notice is $550, it's going to look like you added a late fee. So even if your lease said that late fees are rent officially, you may get the unwelcome attention of defense attorneys that think that they're going to get your case dismissed and then you'll have to pay their fees. So I really recommend that you just ask for the face value rent as shown on the lease, and don't add those extra fees because it does attract attention, which you don't want, because if they file defensive motions, you may end up getting a mediation or a hearing, which will slow your case down. If you ask for more rent than is actually due, your notice is defective. So then you will lose the case. So if there's any doubt about what's due, then ask for the smaller of the amounts. Another thing is, if the tenant is still there after the end of the tenancy, which would be if the lease has an end date and that end date is passed, let's say the lease ended July 31st and it's August 5th, you do not give the tenant a 3-day notice, because by issuing a 3-day notice, you're giving the tenant an invitation to pay that amount of money. So if a written lease ended July 31 and you give them a 3-day notice on August 5th, you just reinstated the tenancy. They're no longer a holdover, because now you've invited them to pay you money to stay in the property. So when the tenant is a holdover, you don't issue any other notices. You just start the eviction. But by giving a 3-day notice, you reinstated the tenancy. I'm defending a tenant. I'm going to file this motion this afternoon where that's exactly what happened. The landlord gave them a notice terminating the tenancy June 30th. And then on July 8th, he gave them a 3-day notice. So he just canceled his termination and restarted the tenancy. So that landlord is in for an unpleasant surprise when he gets my motion. All right, when can you serve the notice? So you can't give a 3-day notice until the rent is overdue. If the rent is due on the 1st of the month, then it is late on the 2nd of the month. So you can't give the 3-day notice on the 1st because it's not late yet, but it is late on the 2nd. Grace periods doesn't mean that the rent isn't late. For instance, if you have a mortgage payment that's due on the 1st, typically the mortgage has a 15-day grace period. That doesn't mean that your payment isn't late. It is late. So you don't have to wait for the grace period to elapse to give the 3-day notice. The rent is still late. The grace period just refers to when the late fee is going to come due. So the 3-day notice can only be done when the rent is late. The other thing is 3-day notices do not include weekends and holidays. So if you give a 3-day notice on a Saturday or a Sunday or on a holiday, those days don't count for the 3 days. Additionally, do not put the due date on a Saturday, Sunday, or holiday, because those days don't count. That will make your notice defective. So officially, the 3 days are considered days that court is in session. So in Florida, every county court system celebrates a separate set of holidays. So you need to check with your county clerk of court to see what holidays are observed in your locality. Broward, Palm Beach, and Dade do not celebrate the same court holidays. They celebrate a lot of the same holidays, but not exactly the same set. There's even counties in other parts of Florida that celebrate things like Confederate Day. So check with your county clerk of court. And here's another thing that can trip you up is that when there's a hurricane, sometimes the courts will close for that. So you'll have to take that into account for your 3-day notice that if the courts are closed, then those days don't count in the 3-day notice. The other thing is that the landlord's address on the notice needs to be in the same county as the property. And I've heard that this is peculiar to Broward, but I think you should take this as a general rule, that if the landlord's address is out of county, then that triggers a rule of civil procedure, which states that any legal document that must be put in the mail, you shall add 5 days to the due date for the mailing. So if you give a 3-day notice to a tenant where you're out of county, therefore the tenant must mail you the rent instead of hand deliver it, then you must add 5 calendar days to the 3 business days. And then weekends and holidays do count in the 5 calendar days, except if the due date falls on a Saturday, Sunday, or holiday, then the due date moves to the next business day. So it gets a little tricky because it's 3 business days plus 5 calendar days. And then if the due date lands on a weekend or holiday, you move to the next business day. So in general, it's probably a better idea to make sure that the notice is posted. Also, if you mail the notice to the tenant, then they are invited to mail you back. So even if you are in the same county, by mailing the notice, the tenant gets to mail you back, so they get the 5 extra days. So the best practice is to use an official form. So I've got all the forms that a landlord would use on my website for free, browardlandlord.com. So really don't make it up yourself, because the law is very strict. You have to fulfill all of the rules. So any deviation from what the statute says means the form is defective. So what are some common mistakes? 1, failure to state on the form that weekends and holidays are excluded. Failure to state the amount of rent due. Adding fees to the rent claim that are not rent. The law also, the statute says that the landlord must include the landlord's name, address, and phone number. So I just had one the other day where a lawyer issued the 3-day notice, and they put the landlord's name, but they didn't put the landlord's address or phone number. They put the law office, but no phone number. So that's another mistake. If you put a PO box as the landlord's address, then you trigger that 5-day rule, because you can't hand deliver anything to a PO box. It has to be mailed. So a PO box always triggers the 5 days. So again, it's the 3-day notice that terminates the tenancy and entitles you to file the eviction. So you can't file the eviction until the 3-day notice is lapsed. So it always has to be filed the next business day after the due date on the notice. When you issue a 3-day notice, you are required to accept full payment of the rent if the tenant tenders it. So you cannot reject a payment. Another mistake landlords make is that the tenant gives them a check and they sit on the check and don't cash it. So if you're holding the check, that's the same as cashing the check. So if you want to proceed with the eviction and not cash the check, you have to give it back immediately. So if you wait a few days, then you've accepted the payment and the 3-day notice is voided out. Some landlords these days have automatic payments that can be done online. So you need to keep an eye on your account to make sure you didn't get the rent, because if you got the rent, the 3-day notice is voided out, and that's not a basis for an eviction. So you're going to have to disable the online payment method in order not to get tagged. A lot of tenants are very sneaky about that, and they'll throw in a payment, not even full payment, but a small payment just to void the notice. Sometimes they'll even do it after the writ of possession is issued. So at any point during the eviction process, if the tenant pays money and you accept it, that cancels the eviction. So keep an eye on that and do not sit on the checks. So in the event that there's a partial payment, it's your choice whether you want to accept it or reject it. So if you accept it, that's fine. You'll just have to issue another 3-day notice. Another choice would be, if you get a payment and you want to proceed with the eviction, you can take that money and deposit it in the court registry. So that would be if you get a payment after the eviction has been filed. So you can take that tenant's money, put it in the court registry, complete the eviction, and then file a motion to have the court registry disperse the money to you. All right, So that is the presentation. Are there any questions?
I think you pretty well covered that really, really well. Thank you.
Oh, I have a question, Alex. I've always been aware about having, the address, the landlord's address in the county where the property is. So can you put the property address as your address if you don't technically live in the county?
Well, you can do a care of address. So if you know somebody else that's in the county that is prepared to accept the rent payment, then you can put them. So I get a lot of clients that are landlords from out of state with Broward County properties. So I do have a 3-day notice that says pay rent to my agent, Attorney Alex Johnson in Fort Lauderdale. So that way they don't have to do the 5 days. But if you have a realtor or another friend in the county, you can just put that address as the landlord address.
And say care of, so put your own name, care of, Mr. Realtor at this address, their telephone number, their everything.
Right. So I do have a form that says pay rent to my agent. So you're going to comply with the statute by having the landlord's name, address, and phone number, even if it's out of state or a PO box, and then say pay my agent. So that is sufficient because you've given the statutory requirements, but also given them a local place to pay the rent. So a lot of people think that, well, they always pay electronically. So what difference does the address make? And the answer to that is that the statute only contemplates one method of payment, which is hand delivery. So no matter what they customarily do on the 3-day notice, the law contemplates the tenant is going to go to that address with the money in his hand and hand deliver it to you. So another little wrinkle is what if the address is an office and the office closes at 5? So some judges feel that the tenant has until midnight to pay the rent. So obviously you're not going to stay at work until midnight. So the answer to that is that there must be a way for them to leave the check at that address.
Oh, boy.
So you need to go check your front door in the morning. I've actually had it where a tenant was directed to pay the rent at my office, and I found a check lying on the floor that they had slid under the door at some point in the evening. So officially they have till midnight, not just 5, to pay the rent. So do check the next morning and make sure that you hadn't got your check, because if they did pay you and you filed the eviction, you just wasted your money. And if they got an attorney, then you're going to have to pay that attorney. And the attorneys are never stingy when they're billing the other side. So you can expect a larger bill.
Well, that was great. Thank you. Thank you so much for all that information.
So a lot of people think that they're saving money by doing their evictions themselves pro se. But the attorney fee that the tenant's attorney will charge you is going to be much bigger than the attorney fee that I would charge you to win the case. So losing the case is twice as expensive as doing it yourself. So now a little comment about the CDC moratorium. So the last moratorium ended July 31st. Everyone was sure, including me, that it would not be extended because the US Supreme Court had said that it would require an act of Congress for a new moratorium, and there wasn't. The US 6th District Federal Court of Appeals said the CDC didn't have the authority to do it to begin with. Biden said that he didn't have the authority to decree it by executive order. So everyone was sure that that was it for the moratorium. And then on August 3rd, they issued a moratorium again. So it's probably illegal, but I think the White House said that good luck getting a court ruling before October 3rd, which is when it ends. So I guess you could say we're now facing an illegal moratorium, but it still has been issued, and I'm sure the courts will respect it. So How does this,
I heard they have money set aside, like for like landlords, banks, things like that, to be able to help in that situation. Like, are they using it? Like, how,
Yeah.
why are people being helped?
there's
We're supposed to
literally
be collecting.
tens of billions of dollars sitting there unclaimed that landlords and tenants could apply for. They were very slow in rolling it out, and that was one of the motivations for extending the moratorium, is that this money, only a fraction of the money has actually been allocated. So they wanted, since the money's already been appropriated, they wanted the money to get out there. So I know here in Broward, every single eviction gets referred to the rent assistance program. Now, it's not mandatory that a landlord participates in it, they could refuse. But every case is referred to the rental assistance program. Certainly, every case that's based on non-payment of rent will go to the rental assistance program. But a lot of judges, overkill on this, and they refer holdover evictions to the assistance program, and even evictions for violation of the lease rules to the program. So you can expect that the judge may throw every single eviction to the program. And that means, as a practical matter, that instead of the judge ruling on the eviction, they're going to set almost every eviction for mediation. So in Broward, there's two forms of mediation. One is the court mediation program, and one is private mediators. So if you get a private mediator, it'll probably be mediated within 7 to 10 days. But with the court program, they're so dysfunctional that I have seen it take 3 weeks to get a mediation date. What if it has to go through the bureaucracy? So that is going to be a big delay in your eviction. The other thing to know about the CDC moratorium is that it's not self-actuating. The tenant must affirmatively plead that they've been economically harmed by COVID. So the CDC did promulgate a form that you're supposed to use, but I noticed when they did the new moratorium, August 3rd, that they stated that you didn't have to use a special form. You just needed to state that you are a qualified person. So the barrier is very low for the tenant to assert this, but the tenant does have to bring up COVID themselves. If they don't say the magic word COVID, then they're not going to get the moratorium. But it's not that strict about what they allege in the form. So I see a lot of them just copy something off the internet and file it. That will be considered good enough. So officially, if they bring it up, your case will be stayed until October 3rd. Now, it is permissible, and it states in the new moratorium that the tenant can challenge the tenants, or the landlord can challenge the tenant's status and state, hey, I don't think that this is true, that they are experiencing hardship because of COVID, and that they are in fact making their best effort to pay the rent. So sometimes you have a tenant that's doing fine economically, and they just think that they can get away with free rent until October. So the landlord can demand an evidentiary hearing where the judge will interrogate the tenant under oath about their hardship. Now, there's not a lot of case law on the COVID moratorium, so the judges pretty much are winging it. So some judges are suspicious of these tenants, and they will really put them through the paces to show that they can't afford it. I had one where I was defending a tenant, and we got the case stayed for the first moratorium, which was October until June. And then the judge brought the case back up for rehearing, and he examined her again. And it turned out that on the Zoom hearing, the tenant was actually in South America at the time of the hearing. So the judge got very angry and said, well, if you can afford to travel to South America, you could afford to have paid your rent. So he denied her the stay and granted the eviction immediately. So some judges are not sympathetic. Other judges will just grant the stay as soon as they say COVID and not even give you the chance to interrogate the tenant under oath. So it ranges from, is all you have to do is say COVID and you got the stay, to the judge saying, I don't believe you, I'm not giving you the stay. So it's going to be done on a case-by-case basis. So we're a little bit past 1 o'clock. Any last questions? No? Well, thank you all very much for coming. I will record the presentation and post it on our Facebook page. The link for the meeting is the same every week, so please share the link with a friend. The more of us that are here, the better networking we can accomplish. So thank you and see you next week. Take
Hey,
care.
Alex, one quick thing. Could you send me that letter, that little contingency letter? When you get time?